U.S. litigation because the rules that set is different. They made this statement specifically about allowance and issue, but I think that this may have an effect later on being able to bring admissions or basically applicants' admissions into the litigation process.
I think that it will, but I think as someone in the litigator hat, I think that litigators who want to use admissions that are in other countries will argue that that should be narrowly construed, because even if they can, as they say, throw a skunk in the jury box, even if you can mention it at all, that's going to cause huge problems. As a litigator, one of the most important parts of the way many if not most of our cases are lost or won are during the claim construction proceeding, which is fascinating. One of my favorite parts is also called a Markman hearing. So the plaintiff who owns the patent sues the defendant, says you're infringing my patent, you're using my invention, you're selling my invention. The defendant almost invariably would automatically come back, no we're not, what I'm doing is not falling within the scope of your invention, and even if it were, your patent's not valid, and much of the time, and even if it was valid and I'm infringing it, it's not enforceable, because you're fraudulent and you're a bad people. So those are almost equivalent. And so the first thing that happens if you're sued for a patent is you order the patent application history from the patent office and you comb it. And litigation is so expensive, there will be people who are 24 hours a day reading every single word that the patent lawyer said, in that case, in the parent, in the grandparent, just to find a gotcha. And that's their job. They will take and twist anything that you say. And you have this whole claim construction proceeding, which is fascinating. I think it's absolutely fascinating, the whole claim construction proceeding. And that's where many of our cases are I would say that probably the majority of places, I'm just speaking from my own experience, where settlement occurs is after the claim construction proceeding, because it can be so black and white that you fall within the scope or you do not fall within the scope. If a defendant gets a favorable claim construction ruling, which would be a ruling which states that the claim must be construed in a fashion which would, by definition, exclude what the defendant is doing. That's when they're going to pound the counsel's going to call for the counsel. I think you want to settle with me now, don't you? Now that claim construction decision can be made by a magistrate and can be often appealed, and you bet it's going to be appealed for whatever side got the claim construction proceeding. But as a defendant, all you need is to fall outside the scope of the claim in one way. You're probably going to make every argument you can make about how we fall outside the scope of the claim this way, and that way, and the other way, and the other way. All you have to do is win on one. You can lose on all the rest. If you win on one, you win. So, if the claim, I'd say just about, as a litigator, I go back to any claim that was listed. Just choose any of them. Let's go back to any claim. I'll come up with a way that you might say the words of the claim, that's fine. The words of the claim are pretty clear. Someone spent a lot of money and time and effort and care and love to get an accurate claim. The claim was considered definite. The claim was considered valid. And can you attack this? Can I attack every word in here? Sure. Preservation. What does preservation really mean? I mean, is it really preserving? For how long does it preserve? Maybe it preserves for a day. The claims in the patent says it's for a week. Well, ours is only 3 days. I guess we don't really preserve it. Let's see. Inclined. What does inclined mean? I say that inclined is defined by what the figures say. It's 3% and ours is 7%. I don't think we meet the definition for what truly inclined is. And I can just, any of these, you can go through any word, upper and lower ends. Is it truly an upper? Is it clear what an upper and lower end truly is here? And I'm just throwing stuff out here. But within the heart, what if it's partly within and partly without? Have I met the definition of really within the heart? So you can take it and you can go through every single word and you can argue that based on what's taught in the claim and the history, that you aren't really that. And about, take the word about, you could always say, about doesn't mean us. About means about 3.5%. What's about 3.5%? Is that 3.6%? Does that fall within the scope? Does 4% fall in the scope? Does 40% fall within the scope? Well, you bet you will argue whatever you have to do to, if you're on the plaintiff side to say that does fall within the scope, or your defendant side. Now, and it becomes this very interesting, fact-specific, looking at the claims, looking at the specifications, looking at the history, and looking at what skill in the art would consider. And even the very grammar. We had this case is free of A and B, and they just have B, are they free of A and B? Or should that have been read free of A or B? So literally, it was looking at grammar books, what does A and or mean, and or mean? What is syntax and semantics about and versus or? What did the other claims, how did they use and or? How did the specification use and or? How did other claims use and or? Because if you're free of A and B, and the defendant is saying, well, we're only free of B, are they free of A and B? Or maybe they meant or, maybe they should have said free A or B, or does that really mean that? That's what it comes down to. So when they blame Clinton for, the definition, I don't know, depending on what the definition of is, to me as a patent litigator, that's perfectly reasonable. I get that. Sometimes it is depending on what the definition of is.
A lot of times in the Markman hearings, to define a claim terms, you go back to the specification, but you can't go back and import the limitations of specification into claim. So how do you take care of that account? You have seen the specification, you know it's limiting, but you can't import back the limitations from the specification.
There's a number of ways to do it. Number one, you can say, without that limitation, that they're going to run into the art. They're obvious, or they're not novel, or they're not enabled. You can say, clearly you can't import a limitation from the specification into the claim, but you can use a specification to construe the claim as written, and that's the argument you have to make. You say you as the defendant who's trying to say that claim is so narrow it doesn't cover what my client does. It's absolutely okay to use the intrinsic evidence of the specification to construe the meaning of the words that are in the claim. You just can't write in a separate limitation. You as the plaintiff patent holder will go, but you are if you do that. And I as the defendant will go, no, I'm just trying to understand what you mean by within. It says within the heart. How would I know what within means if it's partly in and partly out? How deep in does it have to be? Whatever it is the word that I need to attack. And there's just no writing that's clear enough that it can't be argued that, well, do you really mean this? Do you really mean that? And I'm not even talking about doctrine of equivalence, where a lot of people get confused about it. Right now, I'm just talking literal infringement. To do an infringement analysis, you look at the accused device or process or whatever, and you compare it to the claims you've had. I'm talking literal infringement. What do those words mean? Now, regardless of what those words mean, and regardless of literal infringement, even if the defendant does not fall within the scope, literally, of course, under doctrine of equivalence, it's potential that there is this, vague penumbra cloud around the claim that extends a little bit beyond the scope of the patent. But as a plaintiff, you don't want to be relying on that, ideally. You're hoping to really win on literal infringement. But as a plaintiff, it's tough sometimes because sometimes to argue that the claim is broad enough to cover the competitor's actions, you have to say that you are you can't run into your own problems when now you're obvious. Because so you have to constantly be broadening the claim as after the fact to cover the competitor's work and then narrowing it to prevent.
Right. So the prosecution, the examination process, you have to be very mindful of that. Intrinsic evidence, extrinsic evidence. You have to think of all these things all the way through. Duty to disclose, you just as maybe even worse than what you put on the record. If you fail to disclose known prior art, you can be sure you've got up from the other side an argument saying that you have committed fraud on the patent office. As patent attorneys, as professionals, if you know of prior art, submit it to the patent office. If you do not, you are jeopardizing your own license to practice law before the patent office and potentially your license to practice law in general. So if you know about a reference, in it goes, you're going to have to deal with it. That's just the way life is. So if your inventors, ask them to check their records. Because during discovery, that's where it comes out, right? The other side says, give us all your records. All records go over. You find that critical reference too late. You have an issue patent too late.
Yes.
So when you interpret United States, when you interpret claim of United States patent, do you look for prosecution history of another country patent?
Of other countries?
Yeah.
Where they might have a patent application in another country?
Yes.
Yeah, you do. There's a number of valuable things you can find from that. Maybe they've disclosed or shown evidence in another country that could be a problem in this country. That might be broad data. There might be a declaration filed in another country that could be useful. that you could try to use as an admission in this country, you definitely want to see. And make sure, and then there was a reference cited, maybe there was a reference cited in Europe so you know that the applicant was aware of that reference, but they didn't cite that reference in the United States. So there's a lot of reasons why you definitely go and look at the other countries and everything that happened in the other countries. Yes?
Yeah, I assume these Markman hearings are publicly available, open to the public?
Not sure that's true in all cases. I would have to.
I'm just wondering if it would be possible for kind of a sit-in.
I bet you that there's definitely ones you can sit into for sure. And there's definitely transcripts available online, I would think, of a lot of these. It's so interesting. They're just so interesting. Yes?
You care to share some stories about the process of interpretation, most specifically when whoever has to make the decision is not as familiar with the technology as you've been taught for?
Sure. I always love to tell stories, but like, you can give a little more detail of your question.
Basically, what happens when you go in front of a judge, like the famous judge that was supposed to decide, not in a patent case, about whether Microsoft can pull Internet Explorer out of Windows and admitted that he doesn't know how to use a mouse.
Oh, so you're talking about where the witness, or the judge itself?
The judge himself and their technical capability. How do you deal with a judge that?
Good question, good question. One case is, the title is slipping out of my head. The judge can hire someone that I think both sides have to split the cost. We've done that. Thank you. Special master is the word. We have that in at least one of our cases. We have a special master, and believe me, litigators will fight about anything. So and every time anyone suggested a special master, both sides said, completely biased against our position, has represented clients on the other side, and we don't want this person. So finding a special master, finding any that the litigators agree on the most minor procedural aspect is almost impossible. But we had a torturous process of interviewing and submitting multiple special masters to find one that we felt was equally plaintiff and biased and defendant biased and branding biased and generic biased and whatever it was for that case, equally on both sides, and who had the technical expertise and had experience doing special master work. I read the papers on being a special master, and they helped me. Both sides have to split the cost of the fees of the special master, and the judge hears the special master.
Yeah. And you do raise a good point, because in addition to the judge is a layperson potentially, and so are the jurors. Now, the examiner is a little further up on the curve, right? So when you draft in the application, you really have to think of all your audiences. It's going to be an examiner. It could be a judge. It could be a jury. It could be a potential licensee. Could be a venture capital person. You have to write so that everybody gets it, understands what is the value of this invention, where does it fit within the world to the human experience. You really want to put that language in so that the judges, the laypeople, they can understand what does this mean to them, and then get into all the enabling technical support that you are required to provide for the claim. So you're absolutely right. You have a judge doesn't know how to use a mouse. He's making a decision. Get him some way. That's advocacy writing at the drafting stage of the application to address all those audiences.
How many pages are you allowing it?
How many pages?
Yeah. I mean, basically, I, for example, have a rule that nobody, other than maybe the examiner, naturally the opposing counsel, will not read beyond the background and the first paragraph of the brief description. I just wonder how do others do it?
You have to give the tools to the litigators. It depends on what level you get into. Is it an enablement question? Is it?
No, I'm asking the advocacy. Generally, how long do you believe a juror is going to stay focused, or a judge is going to stay focused into the application after the first hearing after in the specification?
I don't know if it's stay focused at all, but I know darn skippy that the litigator is going to look at on your side is to look for every word, looking for gleaning that language that they can do a big blow up for the juror of that sentence or that paragraph. So I don't limit it in that way. I would never limit it on the grounds that I'd be concerned that the juror is getting bored. That's the litigator's job, to do a great job of having good blow ups and slides that show the most important paragraphs. I would never expect a poor juror to sit there and read a patent application. maybe have one available to get them by, but there has to be enough meat in there to blow up. And when we're actually the hiring partners of the firm, and one of the things we really require is excellent oral reading and writing skills, regardless of technical skills, and regardless of the number of PhDs, because it's such an important part of the job. I feel the exact same way. And when you're writing, you're writing for such a very for a juror or for an examiner or for whoever. And sometimes what I do in an interview is I say, I'm a biotech person, I don't understand optics and lasers at all. Explain to me your technology. Explain to me this paper, your favorite paper. What was your research on? And I expect them to try to tailor to their audience and give me a few sentences of what it is, and I respect that if they do, because it shows this is a person who can tone down their jargon to speak to other people. So I do think that that's one of the important things we do for the business and for the law is to write in ways that are convincing and advocacy is what we do. Absolutely. Duty to disclose, we don't have a lot of time, but it's such an important topic. Let's just really fast say, as litigators, of course, it's killer and awful if for the plaintiff, if we could show that they should have disclosed something that they obviously should have disclosed. Who's under a duty of disclosure, by the way? Who's required to disclose? Inventor? The owner of the company? People in the company who should know? The patent lawyer? People working with the patent lawyer? All of those people are under the rule of CFR 1.5 to disclose, not just the inventor. People are imbued with expectation that they know certain things that they wouldn't even know because they work in a company with the person. There's just an assumption, at least, that you have to overcome to say that they wouldn't know it. And it becomes difficult. You might say, well, I know this prior art reference. I should cite this prior art reference. Well, that's easy. What about when you have 69 applications filed in 70 countries, and sometimes those cases, each country will cite their version of the same patent application. So, there was one patent application that was filed in Europe and a TCT in Japan. Do you cite, do you include all of those? Do you include all your own continuation and part applications that are published? What do you include? And if you're, God forbid, if you're a related application that's being litigated, that's very difficult. What do you submit from the litigation to the patent office? Your duty is this, not very clear duty. It's anything that could be relevant to the patent examiner, to your position, or to the other position with patentability to an objective person. So what do you include in the litigation? Well, some things might be easy. The fact that there is a litigation in a related case, that seems like a reasonable thing to disclose. What about the complaint? Okay, maybe. What about the counter defenses, the validity defenses? Do you file in the patent office the defendant's validity defenses to say that the related application is not valid? All right, maybe you do that. What about the discovery? What about when they submit a whole bunch of stuff? Do you include that? Okay, maybe. All right. What if they depose your inventor for 7 hours in Chicago in the dark? 7 hours, hundreds of pages, and in that, maybe there's some quotes that don't look very good because the inventor was sweating and tired, exhausted, and didn't really understand. And maybe he made some horrible statements on the record, like, maybe that's not all over that. What do you do with that? So it becomes a very difficult thing. And remember, you're not supposed to cite too much cumulative stuff. You're not supposed to bury a reference either. So then what? Maybe it would look like you were burying a reference if you cite a zillion things. Overall, the best I can say is, when in doubt, I cite, right or wrong. I think it's a safer position. That you've at least, made it your best attempt, put your best foot forward to disclose everything you believe is relevant. But it can be very tricky. But as we know from the McKesson case, you have to even cite to your patent examiner that the same examiner allowed a related case. I mean, I sympathize with that patent lawyer. You probably figure the examiner knows that they just allowed a related case, but even that can become something that's important. So just be very careful. Don't fall into a trap there. You don't want to lose your license. You don't want to make the patent unenforceable and get sued by your client. Try to disclose everything that you believe is relevant and important, particularly from people.
I have an interesting point about the fact that the examiner may not remember tomorrow what we issued today. You, as a patent practitioner, are expected to remember everything, including cases that were 7 years ago, somewhat related, maybe considered, etc.
And what's really related? How related the claims that are being litigated have to be to your claims to be litigated?
So this is just, if anyone's not seen a patent, this is what the front page would look like. Some interesting information here. Example of references, the patent number, the title, the applicant, the assignee ought to be there, the number, the examiner, the attorney, and an abstract. Down at the bottom is a most representative drawing. So one thing you should realize is look at the front page as this is what's going to get your client that license, that $1 million license that they really need. And the way you got to do it, you got to sell to the potential licensee who's going to be a business guy making a decision. Say, here's the figure. This is really applicable to you, and the abstract make it really relevant. It's a sales pitch. Right? That's you talk about people not having much time to read through. They're going to spend 2 minutes if the business guy doesn't understand what is the invention is, why is it relevant to his business. He's going to move on. If it's all technical jargon and doesn't relate to the human experience, you're probably not going to do the best you can for your client. So you want to make it really relevant to people who are going to look at it. And don't forget the other audiences, judges, juries, all that.
We've covered this basically, but just for the sake of completeness, I know we've covered most of this. Continuation application you file, which would have the same exact specifications substantially, other than changing a few procedural aspects, but a different claim set. Sometimes this is valuable to keep a continuation application on file, particularly if you might be entering litigation. It's a chance to at least keep your options open to file new claims, broader claims, different claims, and maintain your earliest priority date, which you would get because it's a straight continuation. So whatever was in the parent would continue on. A continuation in part application, that's a judgment decision. You can get the earliest effective filing date and claim that for your claims to the extent that they are supported in the original application, not to the extent that they rely on any of the new data. So sometimes it may make sense to just file a brand new application that's not related, because you could be cutting back on your ultimate patent term, which stems from your earliest priority date, and yet not confer much benefit. So that's a decision you need to make. A divisional application, that's particularly useful if when you file your first application, the examiner says, there's too many inventions here, I can't search and examine all of these different inventions. Give claims to the kitchen sink, it's 100 things here, it would take me forever to get these claims. The examiner may make a restriction requirement saying, I will examine only these claims right now. You will have to have those other claims examined later on. A divisional application is a way and means to have the examiner examine that subject matter. And as you would expect, these continuation applications and divisional applications have to be filed while the current application is pending.
Right. So you can do it earlier, try to get the patents earlier, but you're going to be paying more fees, multiple applications in parallel. So it's business decision.
Okay, we've discussed licensing and sale, attraction of investment and enforcement woven throughout this talk. Just things to keep in mind. If you are planning to enforce your patent, you want to maintain it. You want to maintain your fees, even if you think you might possibly want them, and not let the case go abandoned. Marking, very interesting topic. You want to appropriately mark your goods or packaging, etc., with the appropriate marks of your patent number. Keeping in mind there are punishments for falsely marking or marking a product or packaging after your patent has expired, which is not really covered by your patent, but that helps you get damages as a way of notice and notifying potential defendants. And keep in mind the timing of your enforcement to make sure it's most advantageous.
We'll just jump right through these. Okay. We'll just jump right through here. Past landmark topics, there's the GATT, doctrine of equivalence, obviousness. We've sort of talked about a few of these. Patentable subject matter, Bilski. So we've covered a few of those, but then there are some other cases here. Patentable subject matter, this is gene-related patents, post-Bilski. There are a few cases on that. So the idea here is just get a sense that there are cases all the time happening that are relevant to the practice. So you really have to stay aware of what's happening, particularly Supreme Court cases.
This is a good example how Bilski did not deal directly with biotechnology sort of a lot of times people think of it as a business method related or related to something more on the machine and device side, but it has a number of biotechnology effects too, like whether or not a piece of a gene is truly patentable subject matter, whether or not methods of detection are necessarily patentable subject matter, or methods of treatment. So even though the original case is not anything to do with biotechnology, it can have ripples and ramifications throughout the different industries.
Let's see. Enforcement, the I4I case, this is actually, in my opinion, one of the most important cases. The Supreme Court's going to hear, I think, in April, we'll know June, July. A clear and convincing standard to invalidate a patent is the current standard. That happened in 1982. That became, once we got the CFC, they moved it to the clear and convincing standard as opposed to preponderance of the evidence standard. I4I case, the argument made is that it should be preponderance of the evidence standard. There's a reference that had not been before the Patent Office, and therefore, how can you use a clear and convincing standard? And it was a document that the inventor had and never disclosed. And then there's another case here, Tokai, which is sort of following up. There was a document before the patent examiner, and the Court of Appeals said, hey, there's an added burden above the clear and convincing standard. My view is that the CFC said, hey, U.S. Supreme Court, don't change clear and convincing, but make it an added burden if a document had been before the Patent Office there, it's clear and convincing as the baseline. False marketing, we just talked about that, but that's a solo cup case. 21 billion lids had been sold after the patent had gone over, and still the lids were marked. So it triggered a whole number of false marking cases after that. State of mind requirement for secondary liability. One of the defendants here said, we don't look to patent them. We try to intentionally ignore whether a product is covered by a patent. So then it became under inducement. Is there infringement where there's no actual knowledge? Somebody specifically tried to avoid that issue. That's the SEB case, and that's before the Supreme Court. I think that just got argued recently before the Supreme Court. Yeah, February 23rd, 2011. I guess in a few months we'll hear about the decision there. And a few ongoing litigation, legislative activities. This administration's been good. A couple new advisory committees that the president instilled here. The statement is protecting American intellectual property is critical to our efforts to promote the innovation that will help grow our economy. All good stuff here. It's nice that the administration seems to really care about intellectual property rights. I think that's good for us in the U.S. and around the world. And this has to do with that Patent Reform Act. If you haven't read it, take a look at a few interesting cases. First to invent, changing in the U.S. to first to file, limiting who can bring false marking claims, creating post-grant opposition proceedings.
With reduced terms of proof.
Right. Easing venue changes will be helpful because there's some allegations of forum shopping where patentees who are suing for patent infringement will go to more favorable venues or believed to be more favorable venues, and this will allow the defendant to have an easier time moving things. There's actually a lot of other interesting aspects too. The way that best mode can and cannot be used to invalidate a patent. There's a number of interesting things in here. And the only caveat I'd give is years ago, when I was co-chairing the Boston Patent Law International Patent Committee, we gave a talk on the sure to be very soon allowed law on getting rid of first to invent, switching to first to file and post-grant opposition. And we actually had foreign associates from countries that had those things, that had post-grant opposition proceedings, and we compared the U.S. legislation that was about to go into effect with the foreign legislation in the different countries, and it didn't happen. So it would be great if some of these things happen, but this is a huge omnibus bill. These 4 we reduced down from like 20 of the completely different provisions. And as you can see, venue changes for litigation is very different from first to invent, first to file. It's its own thing. There's a million other aspects in here. So how it ends up, it has left the Senate, it's with the House, but what legislation we end up getting in the long run, we'll have to see, wait and see. don't treat, it's easy to get sucked into exciting, sexy legislation and think that's gonna be the law, but it may not be. Yeah.
One more interesting provision is allowing the patent office to set his own fees. Considering that about 2 years ago, we had the TAFAS and KKS case where the patent office tried basically to eliminate continuations. Now we have the capability to do it if that law, heaven forbid, that bill, heaven forbid, becomes the law.
Yeah. Well, interesting ramifications. So that's all part of the job, because you know what? Fines are going to come after you. And if it does change from the first to amend to first to file, what does that happen to that case where we won the swearing behind?
Yeah, what does it happen to all the cases that are?
So it is important to your job as patent practitioners. You got to stay up with all of this subject matter. So and this is all part of it. It's some world looking for counterfeiting and piracy. There's some good. WIPO has put some good groups together so we can talk about all these international issues. Try to get people, different countries, to respect intellectual property. And some more standing committees on trying to get harmonization around the world. And that's it. That's it. So.